Hello, everyone. My name is Claire Hall. I'm a legal director here at VWV, and I specialise in information law, which includes a lot of data protection, particularly a lot of data protection work for charities in particular. So this is very much my area of expertise. I will hopefully be joined later today by my colleague Bronwyn Jones, who is a senior associate in the team. Next slide, please. Today's session is being recorded, so you will receive a recording of it in the next week or so. So don't worry too much about frantically taking notes. You will get a recording. We will be taking questions at the end. So if you have any questions, there should be a Q&A box to put your questions in, and we will take those at the end. I'm hoping to leave around 10 minutes at the end to take questions. So the agenda for this morning's webinar is I'm going to start off by talking about personal data breaches, which remain a high-risk area for charities, and then most importantly, focus on some of the practical things that your charity can do to avoid having a breach in the first place, and then also some top tips on what to do should you experience a data breach. My colleague Bronwyn will then be covering off subject access requests. We are finding that charities are receiving a large number of subject access requests, and that number seems to be steadily increasing as well. So Bronwyn will be providing you with some top tips for managing particularly complex subject access requests, because we do find that they are often made within the context of grievances, complaints, trustee disputes, that type of thing. And then I will finish off today's session by talking about the data protection compliance aspects of fundraising and marketing, which obviously is essential for a lot of charities. Next slide, please. Next slide as well, please. Brilliant. Thank you very much. So, personal data breaches. I thought I'd start with the scariest of the topics just to get it out there in the kind of at the front of the webinar. So I imagine that most of you who are on this session today do have hopefully some experience of data protection compliance. And if you do, data breaches will hopefully be top of mind because they remain a high risk area for data protection compliance. There are particular risks for charities, which is why I wanted to start by covering off data breaches this morning. The first thing I want to cover off, though, is kind of the essential knowledge that you need to have around personal data breaches, which starts first and foremost with actually what a personal data breach is. Because you, as the kind of compliance lead for your charity, or the data protection lead, I should say, you need to have an understanding of what a data breach is so that you can put measures in place to make sure that you are recognizing if you have a data breach, and also to roll out training to your staff members, volunteers, so they can also recognize, when a data breach or suspected data breach has taken place. So I've put the kind of the legal definition of a personal data breach taken from the GDPR on the slide. So the starting point is that a data breach, a personal data breach under the UK GDPR is a breach of security. That's the starting point. It has to be a breach of security leading to one of a few things. So specifically, the GDPR talks about the accidental and unlawful destruction of personal data. So if personal data that you actually need to keep has been, I don't know, stolen by a cybercriminal and deleted, that would be a data breach. If it's been lost, and it could be lost in a variety of ways, a staff member might accidentally leave some papers on the train on the way to work, that type of thing. But loss is actually broader than that. And the ICO, the data protection regulator's opinion, is that loss actually includes things like loss of availability of data as well. So it's interpreted quite broadly. if personal data is unlawfully altered. So let's say you have a rogue employee who decides to go through your charity donor database and change everybody's details because they're, I don't know, angry at your charity. That would be a kind of an unlawful alteration of data. So the point I really wanted to get across is that I think when we think about personal data breaches, we think about the obvious things, don't we? We think about the kind of the cyber criminals. We think about, you know, as I said, someone accidentally leaving personal data somewhere they shouldn't, losing it that way. But it is broader than that, according to the regulator. So do bear that in mind when you are kind of going about your day-to-day jobs, but also when you are kind of writing data protection procedures and policies and rolling out staff training. So it is relatively broad. The Information Commissioner's Office, who I've mentioned a couple of times already, they are the data protection regulator. But in addition to regulating and enforcing the law, they do have a wealth of really helpful guidance on their website, which goes through again in detail what actually counts as a personal data breach. So if in doubt, you might want to take legal advice, but also the ICO's website is there as a really useful resource for you. So why am I talking about data breaches up front? So I've already mentioned that they are one of the high risk areas for charities, but specifically, what are those risks? So I think when we think about the risks around data breaches, the first thing we think about is the risk of a fine from the Information Commissioner's Office. Now, when GDPR came in 2018, we didn't really know what to expect in terms of the level of fines from the ICO. The big change was that the ICO now have the ability post 2018 to issue very, very large fines. However, we haven't actually seen the ICO issue that many fines. The ICO do seem to be taking quite a proportionate approach to their enforcement action. And they are as well using other enforcement action at their disposal, such as reprimands as well as fines. So the ICO risks really are broader than fines, and they include things like enforcement notices and reprimands from the ICO that don't have a monetary kind of side to them, but still risk leading to reputational damage for your charity. And reputational damage really, I think, is one of the key risks for charities, because you are very much, as a sector, your reputation is really everything, isn't it? You know, you need people to think of you in a nice kind of hold you in high esteem, as it were, to be able to really function as a charity. So reputational damage is definitely still a risk there. The other risk that we are seeing develop, as it were, is the risk of claims from individuals. So individuals are able to bring compensation claims for any breach of the UK GDPR, not just personal data breaches, any breach at all, if they can show that they have suffered some damage or some distress. Now, there is a de minimis threshold for that, but often data breaches do lead to damage and distress to individuals. So compensation from claims from individuals are absolutely a key risk that your charity should be aware of around personal data breaches. And the last risk I really want to mention is the risk of your charity's limited kind of time and resources being spent having to put things right if something were to go wrong, which is why, as ever, it's much better to put these things, to prevent these things from happening in the first place than to have to deal with a serious data breach. Which brings me on nicely to my next slide, please, which is how to guard against data breaches. So I've done the scary bit up front, why this is all really important. But what must your charity do to prevent these data breaches from happening in the first place? So the UK GDPR explicitly states that you must put both organizational and technical measures in place to keep personal data secure. So I'm going to dig in a little bit now to what organizational measures means and what technical measures means. Now, what is appropriate for your particular charity is going to be very much a case-by-case judgment call. What is appropriate for a very large charity that processes a huge amount of very sensitive medical data, for example, mental health data, safeguarding data, what's appropriate for that type of charity is going to be different from what's appropriate from a very small charity that doesn't really process a huge amount of personal data and the personal data it does process is of limited sensitivity. So again, case by case here. This is why the GDPR has to be quite broad in what it says about your obligations, because the GDPR, as you know, covers all organizations that process personal data, ranging from small ones to really, multinational corporations. So that's why it uses a lot of words like appropriate. So you need to decide what's appropriate for your charity based on the particular risks involving, which will stem from the type of data that you hold and also the purposes for which you hold that data. So organizational measures, let's talk about organizational measures first. Organizational measures includes things like policies and guidance for your staff, your trustees, and your volunteers. This is not something that's just for staff members. So if you are a charity that also has a large number of volunteers of any type, really, that handle personal data in any way, those volunteers should also be subject to your data protection training, guidance, policies, and procedures. Training is absolutely vital. You need to build a culture of data protection compliance at your charity. And this goes from volunteers who maybe only do a few hours for you every month up to, your chair of trustees. It's a whole charity thing, training. You need to build that culture. Now, it might be that there are certain more senior people at your charity, including those of you on this call, who need more in-depth training. But everybody who processes, and processes includes doing anything with personal data, including just storing it, anyone who processes personal data at your charity must have data protection training. That should take place on induction, so before they start handling personal data to begin with, and then refreshed at regular intervals, ideally on an annual basis. Now, that's the formal kind of training, but I'm a big believer also in just regular updates about information security. Like if you have a newsletter you send out to your staff members, or just a regular bulletin, or regular staff meetings, just spend, a little bit of time in those regular meetings, or put a paragraph or two in a newsletter that goes to staff members regularly, reminding people of the importance of information and data security. Second thing to cover is technical measures. Now, this is really kind of what I see as the IT side of information security. So it includes things like making sure you are using encryption where appropriate, making sure that any accounts are using what's called multi-factor authentication. So to get onto an account, you shouldn't just need a username and password. You should also have some form of additional information that you have to input that's generated, for example, each time you want to log in. So it might be that you use sometimes you can get apps that kind of provide an additional token of information. You will all, I imagine, use multi-factor authentication in your personal life for things like online banking. Do make sure that you are rolling out things like multi-factor authentication at your charity, because it can be an absolute, really kind of just an extra layer of protection that sometimes can really save you from having a data breach. Now, these technical things, if you are a charity that has an in-house IT team, I would expect them to be leading on this type of thing. But if you're a smaller charity that maybe has an external IT provider, do make sure that they are also able to help you with this information security side of things. The National Cybersecurity Centre produce a wealth of guidance for all types of organisations on cybersecurity and information security. They've actually just released some new guidance on multi-factor authentication, which I recommend having a look at, or encouraging your IT provider, IT team to look at. The reason I specifically want to mention the National Cybersecurity Centre in particular around data breaches is that if you do have a data breach, when the ICO are potentially investigating what went wrong, if they think it's a serious enough data breach to warrant them looking into it, they will take into account in a lot of cases whether you are following the National Cybersecurity Centre guidance, because that is seen as the standard at which organisations should be meeting. So please do make sure that you, or the person at your charity responsible for cybersecurity and kind of online security, is familiar and staying up to date with that National Cybersecurity Centre guidance. So as I said, coming back to the point I made a moment ago, what is appropriate for your charity is going to vary on a case-by-case basis. But as a minimum, all charities must have in place both organisational and technical measures. Next slide, please. So what to do if you do have a personal data breach? First of all, you should be planning for these things in advance. Don't wait until it actually happens. You should have, ideally, I recommend that charities have some form of data breach procedure in place that you can turn to if you've had a data breach or a suspected data breach. And please keep a copy of that data breach procedure offline, because if you have a cyber attack and your online systems go down and you're keeping a copy of it on your systems, you're not going to have access to it. So keep a hard copy of that procedure somewhere safe, offline, preferably somewhere that's flood and fireproof as well. Because that's the document that you will turn to if you think you've had a data breach. And that procedure should cover things like who needs to be involved. Now, who needs to be involved in a particular data breach will vary depending on the context of that data breach. So if it's a data breach that involves a lot of a lot of staff information, you will probably want to involve whoever is responsible at your charity for HR. If it's a cyber breach, then you'll want to make sure that your IT team are involved. You might also want to bring in external IT forensics if you need to. You might want to take legal advice on things like your reporting obligations, which I'll cover off in a moment. So think in advance who might need to be involved, because when you have a data breach, it can be quite a scary, panicky kind of situation. So having a document you can turn to that talks you through the things to think about can be really, really helpful. So I mentioned notification a moment ago. There are a few people that you might need to notify if you have a data breach. It does vary though, depending on the severity of that data breach and also potentially the context of that data breach as well. So you do have to notify the Information Commissioner's Office of data breaches unless it is unlikely to lead to a risk to individuals. Again, there's a judgment call there. The ICO do actually have quite a useful self-assessment on their website that's useful to look at. And obviously, you are always welcome to take legal advice as well from VWV on whether we consider it is reportable to the Information Commissioner's Office. You have an obligation to notify the affected individuals about a data breach if it is likely to lead to high risk to them. And really the purpose behind notifying individuals is to allow them often to protect themselves, which is almost part of thinking about how you are containing a breach. Because obviously the first thing we really want to think about is how can we contain a breach? How can we prevent it from getting worse and worse and worse? How can we limit access to whoever shouldn't have access to data, that type of thing. Now, there might be situations where you voluntarily want to notify individuals, and that's kind of part of a broader strategy where we're thinking about reputational management. What we don't want is for wild rumors to be flying around what might have happened. So there are certain circumstances where it's good to notify the affected individuals, even if you're not legally required to. Again, this is a judgment call. And this is something that you might want to talk through with lawyers such as VWV if you do have a data breach. The Charity Commission also expect to be notified via the serious incident reporting procedure in the context of certain types of data breaches. So do have a look at the guidance the Charity Commission has published on serious incident reporting. And ultimately, it's the decision for your trustees, I think, whether the Charity Commission need to be notified. And again, we have a very, very well-respected charity law team at VWV that regularly advise on liaising with the Charity Commission. So obviously, please do feel free to get in touch with us if you would like assistance with that type of serious incident reporting. On the other side of things, there are people you might want to get in touch with to help you to deal with a data breach. Obviously, I've mentioned lawyers already, but on the technical side of things, You might want to, if you think you've had a cyber attack, a cyber breach, some form of fraud, Action Fraud, who are part of the police, can help with that type of thing. The National Cybersecurity Centre, who I've mentioned already in the context of their guidance, can also help, I think, with cyber breaches. You should also think about whether you need to notify your insurers because of the risk of the claims that I mentioned earlier as well. So this is the type of thing that data breach procedure I mentioned earlier should include, because I've obviously mentioned quite a lot of things already. And these are a lot of things to hold in your head. So having that data breach procedure that talks you through these things is really, really helpful. Almost acts as like a checklist if you do ever have a data breach. Now, I've talked about kind of serious data breaches that might need to be notified, but actually all data breaches, some of which are not particularly serious and can be very easily contained and, the risks mitigated. All data breaches have to be recorded on your data breach. Some people call it a register, some people call it a log. They have to be on there, all of them. And that includes basically what's happened, the potential effects, and what you've done to remedy the data breach. Now, I think that whilst that sounds quite scary, actually a really useful resource because it allows you to spot trends. So if you notice, for example, that every Friday your staff members are sending emails to the wrong people, that suggests maybe some training is needed. Maybe staff members need to be told that, why is it Fridays? Are people tired? Are people rushing to get work done? This is the type of thing that you can spot if you have an up-to-date and thorough data breach register. So it allows you to do that kind of lessons learned exercise. Also allows you to consider whether the measures that you've got in place, those technical measures and those organizational measures, allows you to kind of stress test whether they are genuinely appropriate or not. Are they effective? Because if you're having loads of data breaches, even if they're not reportable data breaches, it suggests you need to think very carefully about making those measures more appropriate for your particular charity. And then last but not least, whenever you have a data breach, even if it's not even a data breach, maybe a near miss data breach as well, do think about carrying out at least a light touch lessons learned exercise. So, one of the most common reasons for a data breach is people sending emails to the wrong people or people attaching the wrong attachment. There are certain things you can do to mitigate the risks of that. So think about next time maybe that happens, speak to the person involved, ask them what would, not in a kind of judgmental way, because these things happen, we're all human, but have a dialogue with your staff members about what they think could prevent these things happening in the first place. Often we think about data protection, I think, too much in a top-heavy way. Sometimes the best ideas for how to prevent these things from happening come from even the most junior of your kind of volunteers and staff members. So do think about carrying out that kind of lessons learned exercise after something has gone wrong. That was a bit of a whistle-stop tour. That data breach procedure I mentioned, we at VWV would be delighted to assist you in putting one of those together. We've done that for a number of different charities, so please do get in touch if that's of interest. Next slide, please. Data protection e-learning. So I mentioned that training is absolutely vital, and that training should be for everyone at your charity who processes personal data. At VWV, we have used our expertise in data protection and in the charity sector to develop e-learning. If this is of interest, a poll has just popped up on the screen. Please do tick if you're interested in finding out more. There's no obligation here, but if you are interested in finding out more, then we do offer a free demonstration of this training. So yeah, let us know if you're interested in finding out more. Brilliant. So I will now hopefully be able to hand over to my colleague Bronwyn, who is a senior associate in the team and who is our resident expert in dealing with subject access requests. So I will pass over to Bronwyn now.
Thanks, Claire. Thank you. Hello, everybody. Good morning. As Claire said, I will be covering subject access requests today, everybody's favourite topic. Just a reminder, there is a Q&A function. So if while I'm talking, there's anything that you wanted to ask, please do pop it in the Q&A and we'll try and get through as many of those as possible at the end. So subject access requests then. Probably the most commonly used right out of all of those in the UK GDPR. What is a subject access request? It's the right for an individual to make a request for a copy of their personal data. They can be enormously taxing on resources. And in the charity sector, where your resources are particularly valuable, I thought it would be helpful to talk you through some top tips to try and cut down on the amount of time and resource expended on handling a subject access request. So I won't go into too much detail on the technicalities, but I'll try and keep it practical so that hopefully you should come away with some ideas for perhaps how you can manage your own way that you're handling your subject access requests. So the first thing to note here is that a subject access request is for a copy of personal data. Personal data means any information relating to an identified or identifiable person. The reason that I'm giving you that definition is that not everything that has someone's name on it is necessarily their personal data. So one way to reduce the risk, the resource required for you to handle the subject access requests is to be really aware of what the entitlement is. This is particularly important when you're handling staff requests, because not every email that a member of staff sends is their personal data. So making sure that you know what personal data you actually hold, where to find it, or who to speak to if you want someone else to help you manage that process. There's really good ICO guidance, as Claire's mentioned when talking about data breaches, but this is also true for subject access requests. Really good ICO guidance, which is very detailed, and it can help you to navigate whether something is or isn't personal data. So they give some nice, helpful examples. For example, where staff are communicating socially to arrange a birthday, then it's possible that that's not personal data. So if you're stuck, that's a good port of call. Obviously, we're always happy to help as well. Bear in mind exactly what's being requested. So does a subject access request need to be in writing? And the answer to that is no. It can be made in any manner. Any request for personal data is a valid subject access request. It doesn't need to mention data protection law, personal data, as in the words personal data, subject access request. It can be mislabeled as a freedom of information request, and it can be made in a meeting or via a telephone call. So as long as what the person is asking for is their personal data, then strictly speaking, that's a subject access request. It also doesn't have to be addressed to a particular person. So everybody here probably has some kind of data protection element to their role and would likely be able to recognize a subject access request. But something to bear in mind is someone could put a request into a generic email address, so inquiries at or help at. If it's a request for personal data, it's still a subject access request. But if the person who manages that mailbox doesn't realize that or isn't aware of data protection law in a particularly detailed way, they might miss it. And it might mean that the subject access request doesn't get responded to in a timely manner or not at all even. So suggestion is that everyone is trained to recognize a subject access request in whatever manner it comes in, and crucially to know who to pass it to in order for it to be dealt with appropriately. What you don't want is that clock running down because it's sitting in someone's inbox, or it was a telephone call and they didn't pass on the memo. If you do receive a request via telephone or in a face-to-face meeting, so if you're in a one-to-one with someone and they say, oh, can you send me a copy of my personnel file? What you'll want to do is make a note of whatever it is they've requested and the date on which they requested it. So this comes back to my first point, bear in mind what's actually being requested. You only need to provide the information within the parameters of the request. Sometimes the temptation is to go overboard and provide lots more, but that actually just ends up with lots more resource being expended on subject access requests that doesn't need to be. So check the request. Have they asked for a particular date range to be searched, or just a certain area of the system, or only individuals within this team, for example? And make sure that you're not doing more than you need to there. Do you need to ask for evidence of ID? If you are sure that the person who's making the request is who they say they are, then you don't need to ask them for ID. So if the person is a member of staff and they've sent the email from their staff email account, that's fairly easy. You can be fairly certain it's them. If it's someone with whom you've got a bit more of a remote relationship, so someone who's made contact via the website or a service user that has been out of touch for a while, you will probably want to check their details against what you hold on your system. And if they don't match or you're just not sure, then go back and ask them to provide some evidence of ID. The purpose of this is so that you can make sure you're not releasing personal data to someone who isn't who they say they are, which can cause all kinds of problems from a data breach perspective. So you need to be satisfied there. You don't need to go overboard with the request for ID. So you don't need sort of bank statement and passport. You just need enough to satisfy yourselves. So if that's attending a Teams call with the person or asking to speak to them next time they're in the office, whatever works best for you, but you need to make sure you're satisfied. People can make requests on behalf of other people. So I think probably the most commonly used one would be if a lawyer made a subject access request for their client's personal data, but you can also have family members making requests on behalf of other family members too. The same principle here applies. You need to be satisfied that the individual whose personal data has been requested, the data subject, is on board with the other person making the request on their behalf. So you need to do what we call seeking authorization. If a solicitor's firm has made the request, they should be providing a form of authority, which is a signed form from their client saying, I consent to Bronwyn making a request on my behalf. If it's a family member, it's a slightly different position. What you'll need is something from the data subject, again, satisfying you that they are happy for the request to be made on their behalf. This might be a phone call, it could be an email from their own email account or something along those lines. If a parent is making a request on behalf of a child, they are fine to do that. If they have parental responsibility, that's fine to do up until roughly the age of 12, which is when children are deemed to be mature enough to start understanding this right and exercising the right themselves. So if you deal with children's data, something to be aware of is the age of the child and whether you need to be asking for authorization from the child. 12 is not a hard and fast rule. It's a guide. So you could have a particularly mature 11-year-old or a particularly immature 13-year-old who sort of fell on either side. It's a judgment call to be made whether or not you need to seek permission from the child too. The deadline for responding, where you're not clear on ID or authorization, doesn't start running until the date that you receive the satisfactory ID or authorization. The next thing to think about is, what if this person's asked for loads and loads of information, which does happen. So people who have perhaps worked at the charity for 25 years, if they ask for everything, clearly that would be an enormous amount of work. You are permitted to ask an individual to clarify what it is that they are seeking. And this can be a way to help you manage the scope of the request and therefore the resource required to prepare the response. So when drafting a clarification, what you're looking for is to get the individual to be more specific and provide you with details which will inform your search strategy and hopefully should provide you with a smaller data set to review. While you're waiting for the person to respond to your clarification, the clock is actually paused. So if it took them 4 days to respond to your request for clarification, then you can add 4 days onto the deadline. So that can be quite helpful as well when you're managing time that you need to spend on this. If they don't respond at all, and there isn't any legal obligation on them to respond, you wait to hear from them. If you've not heard by, say, a month, then the ICO guidance says that you can close the request because you just haven't heard back from them. Calculating the deadline. There's a lot of misinformation around Is it 30 days? Is it 28 days, the deadline? The deadline is 1 calendar month from the date that you receive either the request or the ID/authorization if you're seeking it. So if you received a request today, which is the 22nd of October, the deadline would be the 22nd of November, 1 calendar month. If that day falls on a weekend, Saturday or Sunday, then your deadline rolls over to the following Monday. So you can end up with different amounts of days depending on what month you're in, whether you've asked for clarification, and also whether your deadline falls on a weekend, which is why 30 days is misinformation. 1 month, though, is still not a huge amount of time, particularly if you're dealing with quite a complex request. You are permitted to extend the deadline by up to an additional 2 months if you're dealing with a complex request. There's no legal definition of what complex is, but as I've mentioned, the ICO guidance on this is really deep, really good. And they actually list 6 factors that can indicate a complex request. So if you think your request is complex and you want to rely on the extension, then you might want to have a look at the ICO website and see if any of the factors that they've mentioned fit the situation of your particular request, because it is context specific. It's not an exhaustive list, but it does help with looking at what types of things you might be considering. For example, if you've sought legal advice, that can indicate a complex request. If you've had technical difficulties retrieving the information, so if it was being restored from an archive, or if you're applying an exemption to a particularly large volume of sensitive information. So if you deal with safeguarding information, you may find that requests for safeguarding information usually are complex. To extend the time frame, you need to notify the individual within the original 1 month deadline and let them know the reason that you consider their request complex. You're notifying them, you're not asking for their permission to extend. Requesters sometimes get confused about that, but it's a notification sent to them. Could I have the next slide, please? William. Right, so let's say you've followed all of those steps, you've got your data set. Hopefully, it's quite a small data set. What's the next step? You need to prepare it for response. So the entitlement is to a copy of the personal data, subject to the exemptions. Majority of the exemptions found in Data Protection Act Schedules 2 and also 3, and the most commonly used ones that we find for charities are the exemption for mixed personal data, third-party personal data, legal professional privilege, so communications with lawyers. Don't forget to watch out for those. If there's been an ongoing complaint and VWV are involved, or whoever your lawyers are involved in helping you to handle the complaint, and then you get a subject access request, you might find that information with your lawyers is brought in by virtue of what's been asked for, but it doesn't necessarily mean that the individual is entitled to see it. What we suggest when you are applying your exemptions is to take a very granular approach. And what I mean by that is look at each piece of personal data and make a decision about whether you think it's exempt. Sometimes the temptation is to decide on a document by document basis, in or out. But actually, what the ICO want you to do is look at each piece of personal data on its own merits, because there may be some things in a document that can be treated in a different way than others, so more sensitive and less sensitive information. Make sure that you keep a note of which exemptions you've relied on. The reason for this is that I will talk about complaints shortly, but the vast majority of subject access requests do end up in a complaint because individuals don't understand that they're entitled to a copy of their personal data subject to exemptions. So they think they're going to get a whole pile of information that they're not entitled to, or that there's a smoking gun in there that maybe just doesn't exist. So if a complaint does proceed to the ICO, they may ask you to justify your position as to why you didn't disclose something. You can then use your nice detailed note on exemptions to form the basis for your response to the ICO. If you don't make a note at the time, because these things can take a little while to process through, you might find that people have forgotten why a decision was taken, or staff members have left and no one knows why they prepared it in the way that they did. So it's just to help you out in the future and save you some time there as well. when you're providing your response, as well as a copy of the personal data, and whether that's redacted original documents or a table where you've extracted the personal data from the original document and put it in there, because the entitlement isn't to original documents. You can present it how you would like, as long as you don't alter the personal data itself. However, you're providing it, you also need to provide a copy of what we call the supplementary information. So in Article 15 of the UK GDPR, you also need to provide, as well as a copy of the personal data, some additional information. For example, information about the sources and recipients of the personal data, whether it's been subject to any international transfers, the categories of personal data caught within the request. What we've found is much of the information that's required there crosses over with what you would put in a privacy notice. So one quite quick way of providing the supplementary information is to provide the relevant privacy notice to accompany the disclosure. For example, if you had a staff request, you'd put your staff privacy notice. If it was from someone who'd made contact via the website, you might put your website privacy notice. You also need to make sure that it's sent securely. If you've spent ages preparing a response and considering exemptions and redacting or extracting, what you wouldn't want to do is then fall down on the security point by it going astray or being accessed unauthorized. So if someone's made a request electronically, you need to provide the response electronically. This should be an encrypted, password protected response. Claire mentioned about multi-factor authentication earlier, and this is relevant here as well. So if you password protect the document, rather than sending the password in an email, because even if you send it in a separate email, if that email account is compromised, the hacker will have both the password and the documents. They'll be able to put them together. What you will want to do is send the password via a different means. So a telephone call, a text message, something along those lines, to make sure that the two are separate and it's kept secure there as well. Some practical considerations then. Do you need to tell the requester when you've relied on an exemption? And the answer to that is there isn't any legal obligation to do so, but you might want to be transparent if it's appropriate. For example, if someone's only asked for a reference and you're relying on the confidential references exemption, it just makes sense to say, we're not providing the reference, we're relying on the confidential references exemption. Now, ideally, you would have covered off in your privacy notice the fact that you keep references confidentially. So you might also want to provide a copy of your privacy notice that says references, whether given or received, are kept confidentially. And that way it sort of bolsters your ability to rely on that exemption there. Save time by planning at the outset. So think about who's reviewing the data. Are you going to review it chronologically? What about drafts? So if you've got drafts, those might still fall within the scope of someone's subject access request. So don't forget to be mindful of, this maybe wasn't intended to be sent to the person. Do we need to give it a bit more thought? Are there any exemptions? Just because it's a draft doesn't mean that it's exempt in itself. Make sure to always keep a copy of the request next to you so you can refer back to it and make sure that you're not putting anything out of scope in there. And be mindful of third parties. So someone's asked me about, can I give an example of exemptions? So third-party personal data or mixed personal data, where you've got information that's about your requester, but also about someone else. So John and Jane have had a disagreement. That's mixed personal data. The position there is you shouldn't disclose it without the consent of the other individual unless it's reasonable in all the circumstances. So whether or not to seek consent is a judgment call, and it depends on the facts of the situation. If two people have really fallen out and just going to seek the other person's consent would reveal the fact that the requester's made a request, it might not be appropriate. So you do have the discretion to consider what's reasonable, and that will depend on the context. If someone's made a really sensitive safeguarding disclosure, you can see that the balancing exercise there would fall in favor of protecting that individual. But if there's information that's really anodyne and already known, Bronwyn and Will went out for lunch to talk about a bill, then you might find that it's okay to disclose. So it really depends on the facts of the situation. Could I have the next slide, please? Okay, so finally, we come to complaints. As I've mentioned earlier, the vast majority of complaints that the ICO seems to receive are about subject access requests. It's completely free to complain to the ICO, which does mean that people feel more inclined to do so because there's no cost to them. It doesn't mean that there's anything in the complaint itself. You could have prepared the response beautifully and perfectly, but unfortunately, people do just complain. Top tips for this: make sure you keep a full record of all your decision making. A good paper trail will be really helpful. If you've asked for clarification, make a note of the dates and what was asked for. If you've extended, make a note of those dates, and that will form the basis of your justification to the ICO should they ask you to look into things. The ICO does publish information about complaints on its website. So Claire mentioned earlier about reputation. That is something to consider here. However, they are mindful of charities and resources. So as long as you've done your best with it, you're unlikely to see any formal enforcement action there. And then the final thing I just wanted to mention is consider the context of the complaint and your relationship to the complainant. So is there a complaints policy that's engaged here? Is this a staff member who's actually raising some kind of a grievance at the same time? You can find that you have a subject access complaint running alongside a wider complaint, and you might want to think about strategy to manage that. We do work with colleagues in our charities teams when we have these on to make sure the approach is joined up and aligned on that one there. Thank you. That was everything from me. So I'm going to hand back over to Claire now to talk through fundraising.
Thank you so much, Bronwyn. That was brilliant. Next slide, please. So everyone, I'm just going to finish off by talking about fundraising and direct marketing compliance, which I know is an area that's very important to a number of charities. And it's also an area where there's a number of kind of myths and misconceptions as well about data protection and e-privacy compliance. I've only got 10 minutes to cover this off, so it's going to be relatively high level. But I think there are some key points that still should be valuable. So first question on the slide is, when are your fundraising activities covered by data protection law? Bit of a trick question, really. So you are covered by data protection law whenever your charity is processing personal data. But in the context of fundraising, there are some particular things to think about. I just want to recap something Bronwyn said a moment ago about the definition of personal data. It is absolutely vital that you understand what personal data is. So just to repeat what Bronwyn said, personal data is information relating to, i.e. about, an identified, and this is the important bit, or identifiable living individual. So deceased people are not covered by personal data. The or identifiable bit, I think, trips up a number of organizations. It basically means that for something to be personal data about a living individual, you don't necessarily need to know who that individual is from the face of the data in question. If you can work out, or if somebody else could work out using means reasonably likely to be used, who the data relates to, for example, by piecing together different pieces of data, then that is still potentially personal data, which means that you cannot get around data protection law by removing names from data if it's still possible to work out who the data is about. Again, it's personal data. What personal data is a minefield, but just that high level point, I think, is really important to bear in mind, because it does trip up a number of organizations in my experience. So just to recap, whenever you are processing personal data in the context of your fundraising activities, you must think about data protection law. There are certain things that I know charities sometimes think about doing, want to do, that are higher risk. Things like wealth profiling, where you are using publicly available information or other information maybe that you're buying from data brokers to build up a picture about how wealthy someone is, so you can target them for fundraising reasons. Things like that, wealth profiling, also data matching, where you are, again, possibly using an external party to give you data you don't already have. These are much higher risk areas of data protection and compliance. I would recommend as a minimum carrying out a data protection impact assessment before doing those activities, looking at the ICO guidance as well on those things. And I would say this because I'm a lawyer, but you might also want to think about taking legal advice because they are higher risk. We also need to think about when we're thinking about fundraising and contacting people to ask them, for example, to support your charity. Maybe you're hosting a fundraising dinner and you want to invite people, things like that. If you are contacting people using electronic communications, so email, text message, social media, DM, and also live telephone call. I'm guessing you guys don't do automated telephone call, but live telephone call as well. We need to think about some particular rules under a different piece of legislation, under the Privacy and Electronic Communications Regulations, which I'm going to call PECA for short today. Now, just to recap this slide, whenever you are processing personal data, which doesn't need to include people's names necessarily, you need to think about your data protection law compliance. Next slide, please. So what are the key things that you should be thinking about when thinking about data protection compliance in this context? Obviously, I can't go through every single thing that you might want to be thinking about, but the 4 things on this slide are a really good starting point. Whenever you are processing personal data, you have to be transparent with individuals about what you are doing with their data, why you are doing it, who you might be sharing it with, that type of thing. And that transparency information is normally published and provided to individuals in a document called either a privacy notice or a privacy policy. If you are doing things like fundraising, you are doing things like wealth profiling and data matching, very privacy intrusive things, absolutely need to make sure that you are being transparent with people about that in your privacy notice, and make sure that you're really drawing those more privacy intrusive things to people's attention. That very much not only is a legal requirement, but also hopefully will minimize the risks of people complaining about it as well, hopefully. Again, it's not a panacea being transparent. And as I said, there are quite high risks around things like wealth profiling and data matching. So I do think, think very carefully about whether you actually want to do these things to begin with. But transparency can get you quite a long way in managing people's expectations about what you are doing with their data. Whenever you process personal data, in whatever context, you need to identify a lawful basis. There are 6 lawful bases under the UK GDPR. In the context of fundraising and direct marketing, the 2 most relevant are consent and legitimate interests. There are certain situations where you have to get consent. The law is very strict on that. And I'm going to cover that off in a moment when we talk about the privacy and electronic communication regulations. Legitimate interests is something that I know a lot of charities try and rely on when actually they're supposed to be getting consent. There are situations, though, where you can rely on legitimate interest where consent is not needed. So, for example, around making live telephone calls to people who are not signed up to the telephone preference service, not signed up to the corporate telephone preference service. Legitimate interest is relevant there. Legitimate interest is also relevant when sending out direct marketing by post. Now, when you rely on legitimate interests, you have to do a balancing exercise. This balancing exercise is essentially weighing up your legitimate interest in processing the data, however you are intending to process it. You're balancing that against essentially the rights and the freedoms of individuals in question. So you'll be thinking about things like, is what we are planning to do within people's reasonable expectations? Is it very privacy intrusive? Is it quite unusual and quite unexpected? If it is, then you might struggle to rely on legitimate interests because the rights and freedoms of that individual might outweigh your legitimate interest. The key is that you are documenting that legitimate interest assessment. So should you get a complaint to the ICO, and the ICO asks you some questions about what you've been doing, you are able to show the ICO that you were aware of data protection compliance and you thought about whether you could rely on legitimate interests and you did a legitimate interests assessment. So as I said, consent and legitimate interests are the two most common lawful bases, and I'll talk about consent in much more detail when we talk about the privacy and electronic communications regulations on the next slide. Data minimization. So there are a number of principles under the UK GDPR. One of those principles I call the data minimization principle. And that essentially means you must only use the minimum amount of data you need to fulfill your objective. And I raise this in the context of things like fundraising and direct marketing, because sometimes I find that charities want to collect data just on the off chance it might be useful in the future. That really does pose a risk because you're collecting more data than you actually need. You'll also, I think, in that context as well, if you don't really need the data, you'll struggle to justify having a lawful basis for that data as well. So do think about how you can minimize the amount of personal data you have in this context as well. Also, holding a limited amount of data minimizes the risk should you have a data breach in the future as well. And last but very not least on this slide, under the UK GDPR, people have the absolute right to object to their personal data being used for direct marketing reasons. Now, direct marketing in a charity context is broad. It includes things like promoting your aims and ideals. It's not limited to just selling commercial goods and services. It's interpreted by the regulator as also including promoting aims and ideals and fundraising. So people have the absolute right to object to you using their personal data for those purposes. And that is regardless of what lawful basis you are relying on. Next slide, please. So PECA, the Privacy and Electronic Communication Regulations. There are quite prescriptive rules in these regulations around sending direct marketing messages. And as I've just explained, direct marketing messages includes things like fundraising appeals, inviting people to a charity event, and that type of thing. You are sending that direct marketing electronically to individuals. Then there's a very strict rule here. Now, I mention individuals because there are different rules. So it's more flexible if you are contacting corporates. So if you want to email me to my VWV email address, I get far less protection at that email address than I do at my personal Hotmail and Gmail accounts, essentially. So the rule I'm about to talk about, it's not business to business or charity to charity. It's when you are going out to individuals by electronic message. And that includes things like social media DM. At the moment, and this might be changing, at the moment, you need consent from that individual to send direct marketing to individuals, unless you can rely on something called the soft opt-in. But unfortunately for charities, the soft opt-in only applies when you got the person's contact details in the course of a sale or negotiations for a sale. So it doesn't help at the moment with fundraising. The previous government, the Conservative government, had a bill going through Parliament that didn't survive the general election that was proposing to extend the soft opt-in to help charities. We don't know yet whether Labour will be doing something similar, but I wouldn't be surprised if they do. So watch this space around that. But at the moment, the rules are really quite strict. If you want to send electronic messages, email, text message, etc., to individuals for direct marketing purposes. There are different rules around live telephone calls, which I've briefly mentioned already. With live telephone calls, you don't need consent, but you do need to check the person is not signed up to the telephone preference service or the corporate telephone preference service, because corporates also get protected under this particular rule, unlike the social media DM, email, text message rule. And you need to check the person has not exercised their right to object that I mentioned earlier as well. Fortunately, because we're talking about electronic communications here, post is not covered by the particularly strict rules under the Privacy and Electronic Communication Regulations. Next slide, please. So I'm conscious that the hour we've had today has been a whistle-stop tour of some of the key things that we are finding charities are thinking about, coming to us for advice on. Bronwyn and I, next year, which feels like a million years away now, 2025, will be hosting a half-day session in our London office, which is near Monument Tube Station, so quite central London, specifically for charities on data protection. We are limiting the spaces to 18 because we find that's a really nice number to get a good conversation going and to make it interactive. So limited spaces are available. There is a small charge, not huge, for the session. If you are interested in signing up for this, when you get sent the recording of today's webinar in about a week's time by our events team, there will be a link there as well, so you can sign up to this session. These types of sessions that Bronwyn and I have done before are incredibly popular because they're in person, you get to meet people who do a similar job to you. So you can share intel with other charities around data protection compliance, as well as hearing more from Bronwyn and I on the topics that we've been discussing today. So yeah, just a shameless plug there, I'm afraid, guys, for the session we'll be doing in London next year. And I think we've got just about 5 minutes left just to take a few questions. So I might hand over to Bronwyn now in case there's been any questions on SARS.
Thanks, Claire. There have been questions on SARS, shockingly. So I'll just answer a couple of those. I'm conscious of the time here. We've had a question around the confidential references exemption that I mentioned. So to clarify about that, there is an exemption in the Data Protection Act which permits you to withhold references given or received in confidence in relation to education, training, employment, volunteers. And you can withhold the entire reference. The question was asking, well, if you just take out the name of the individual who gave the reference, that's protecting them. And that's to do with the protection of third-party data, but the reference itself could just be withheld entirely. The point that I was making around transparency, and it feeds into what Claire was saying really, is that if you are transparent with individuals about the way in which you use their personal data, so you say in a privacy notice, we treat references in confidence, then it's no surprise when they don't receive a copy of the reference, because you can refer back to a privacy notice that they should have been provided with a copy of at the outset of collecting their personal data. So it just helps you to justify that position if you do want to take a strong line and withhold the reference. You don't have to rely on an exemption as well. I feel like it's important to make this point. So if you feel comfortable that you'd rather be transparent with the references that you've given, then by all means disclose them. But I suppose a cautionary tale would be if you're disclosing a reference that someone else has given, then you may want to check in with them about their approach there as well. We also had a question about an individual making a subject access request on behalf of someone who is deceased. So again, coming back to this definition of personal data, and thank you, Claire, for picking up on that point, it's living individuals that are caught by the definition of personal data. So it wouldn't be a subject access request at that point because they aren't caught within the data protection law definitions there, because they are no longer alive. Claire, were there any that you wanted to...
Thank you very much, Bronwyn. Yeah, I've just got one very quick question that I can answer here, which is a breach of PECA, so sending someone a fundraising email that they haven't consented to receive, is that a personal data breach under the UK GDPR? The straightforward answer is no, because a personal data breach has a very specific definition. It's a breach of security leading to the loss of availability, loss of confidentiality, loss of availability of personal data. But it might be a broader breach of the UK GDPR requirements more generally. So there is a distinction between a personal data breach, which has obligations around notifying the ICO in certain circumstances, and a broader just breach of the GDPR more generally, because you might breach the GDPR more generally by not responding to a SAR within 1 calendar month or something like that. So in the context of PECA, you might have breached the requirement to have a lawful basis. Because if you are required to get consent under PECA, the ICO's view is that consent is therefore the appropriate lawful basis under the UK GDPR as well. So a bit of a nuanced one there, but the straightforward answer is no, it's not a personal data breach as defined on the first slide in the slide deck. Guys, thank you so much for asking great questions. Thank you so much for coming out today. Apologies, we've overrun a bit. It just goes to show how passionate Bronwyn and I are about data protection compliance for charities. So hope to see some of you in February in our London office. But without further ado, you'll get a recording in the next week or so, and you'll also get a copy of the slides as well. So thank you so much for attending today. I hope you have a great rest of the day. Bye, everyone.